Our today's topic is legal right. Let me share with you, to have access to this legal system, one must possess a legal right. Unless you have a legal right, you cannot stand before courts and seek a remedy from it or solution from it. Therefore, it is ideal for all of us to understand what is meant by right and how we acquire right. In this tutorial, we study what is meant by right, what are the various modes through which we acquire a right. Let me also tell you, when a lawyer is confronted with a social problem through his client, he should understand what is the legal right of his client gets violated. Unless he ascertains through his discussion with his client that there is an infringement of legal right, his discussion has no relevance. Therefore, it is all the more important for a lawyer to have a better client interaction to understand what is meant by legal right. Let me also share with you, our legal system is primarily constructed on the premise of legal right. Even otherwise, if we study the definition given for decree under CPC or a definition given for complaint under CRPC, it is evident that one must possess a legal right to approach court. And the courts are meant to primarily determine legal rights in favor of persons in order to grant relief. Right or liability. Right or liability are like two sides of a same coin. So whenever there is a right in favor of a person, it means that some person has a liability to discharge. If he violates that liability, definitely he would be penalized or subjected to some sanctions. That is the basic thing which everybody should know, being a lawyer especially. Now coming to the issue, how we acquire rights. A person can acquire in various ways. It can be by way of a constitution, that is a basic document on which the state itself is created, or laws which are enacted by the state through appropriate legislatures, or by the parties themselves by entering into a contract, or because of custom. These are the various channels through which one can acquire a legal right. Now, coming to the first method of acquiring rights, that is our constitution. Under constitution, in the very beginning, it is clearly mentioned various rights which our constitution has granted. They are like right to life, right to equality, freedom of speech and expression, and pursue a religion of one's own choice, and cultural and educational rights. They are all rights which are recognized by the constitution itself. Once a right is recognized under constitution, it carries higher weight, and it is remedied or redressed through higher courts like High Court and Supreme Court under writ jurisdiction. And next is statutory rights. These are the rights which are acquired by persons in view of a law made by the appropriate legislature. It can be the state legislature or union legislature. The statutory rights can be studied under two heads: public rights, personal rights. Public rights head, we can study right to information and right to work. Let me also share with you, whatever rights which we are discussing here, they are only illustrative, they are not exhaustive. Right to information, under this, any person who has a who needs information from any public authority by making an application can certainly demand information from any public authority. This is a right recognized by way of a law itself. Similarly, right to work. Any person in the rural village, if he is an employee, if he wants to work, definitely by making an application to competent authority can seek employment. If it is not provided, he will be appropriately compensated. And next, personal rights. Under the tag of personal rights, we have variety of rights like marriage, divorce, adoption, custody of child, inheritance, all these things. If we read Hindu laws like Hindu Marriage Act, Succession Act, or Maintenance and Adoption Act, all these rights are recognized by the law itself. If a person who got married, if his marriage is not in accordance, or he is subjected to certain problems which are mentioned under section 13 of Hindu Marriage Act, definitely he or she can make an application for divorce. Thus, thus divorce itself is a right recognized under law itself. Similarly, a person who meets with certain requirements can definitely adopt a child. The same is the case with right to seek maintenance. For example, a woman who is been neglected by his husband definitely can make a claim for seeking maintenance, and that right is recognized under law. Thus, a person whose right is recognized under law can make a claim. Thus, all the more important is whenever a person reporting a grievance to a lawyer, the lawyer should understand whether that grievance, that emotional problem, whether it is recognized as a legal right. In order to know whether it is recognized legal right or not, lawyer must be thorough with appropriate legal rights. Thereafter, he can properly and clearly can have a discussion and ascertain appropriate facts from his client. And last important right which we should understand is inheritance. Generally, in the event of death, the property of the deceased must go to some persons. Law recognized, especially under Hindu Succession Act, certain Hindus who are entitled to receive the benefits or property of the deceased person. Thus, any person who falls within that category, either class 1 legal heir, class 2 legal heir, definitely, according to the rules fixed therein, make a claim that being a particular person recognized under law, he is entitled to the particular extent of the property of the deceased. Thus, to make a claim, we should understand that there must be a recognized right, and all these rights are recognized by law itself. Now, coming to the next concept, contractual. Contract, we know it's agreement enforceable by law, generally between two persons. Purchasing an immovable property or any movable goods, it is done by way of a sale by two individual persons. It's a contract through which parties themselves fixes their rights and liabilities. In the event of violation of liabilities or rights, definitely one can sue another subject to loss. The same is the case with mortgage, pledge, lease, or easement. The right of easement can be acquired not only by way of a custom, not only by way of a law, but also by way of a contract for the beneficial enjoyment of one's own land. If there is a violation of contract of easement, definitely they can make a claim by filing an appropriate suit. Similarly, lease also a contract. The rights of a lessor and lessee is based upon a contract. In the event of violation of that contractual rights and liabilities, definitely one can sue. The point to be taken is a person can acquire rights by way of a contract also. If a right is acquired by way of a contract, definitely in the event of violation, one can approach court. Next is customary rights. Apart from constitutional, contractual and statutory rights, a person may acquire rights by way of a custom also. Under our Indian law, the following are some of the rights which can be acquired by way of a custom also. For example, right of a partition by Hindu co-partner to seek for partition and demand his share is also recognized by way of a custom. To put it otherwise, these customary rights are in existence from a long time. They are recognized as a rights because they are been in existence from a long time. They are being followed by the people as if they are binding upon them. They are not against public policy or any law prevailing in the country. Similarly, under Muslim law also, we have a concept of divorce. It is a customary right. It is not a contractual right. Under Hindu law, divorce is recognized after 1955, whereas under divorce for a Muslim is there much prior to 1955. That's why it is called a customary right. Right to seek divorce by a Muslim is not a right recognized by law. It's a right recognized by custom itself. So the point to be taken is, in order to seek and approach court a right, in order to approach court, one must possess a legal right. And in order to have a better discussion with a client and to ascertain whether he has a legal right or not, there must be a proper thorough discussion with the client. And generally client will not be ventured to speak about these technical affairs. We shall, through a thorough discussion, having been aware of variety of rights and their mode of acquisition, shall understand what legal right gets infringed, and accordingly we file a and prepare a appropriate draft to make a claim before the court. So our submission is one must be very thorough with the concept of rights. That's the end of class.